This commentary exists largely due to a post on Blue Sky from the New York Times Pitchbot account, which is also one of my favorite political satire accounts and one I'd recommend you all follow. On June 21st, 2025, the account in question posted the Manhattan Institute, then and now, along with 2 screenshots. Said screenshots being of headlines from the Manhattan Institute, the first of which reads, "Universities have become so terrified of free speech, I've launched a faculty of common sense." And the second of which asks, "Is free speech too sacred?" For those curious, the first article is one taken from the Daily Mail, a news outlet not exactly known for its credibility, by the way.
I read my dad's newspaper and I jumped out of my chair when I saw the headlines. It read, "Fire started in Eisenhower Middle School by unknown entity."
What newspaper does your dad read where it would state that?
The Daily Mail.
No, it would have said Foreigner. It's Daily Mail.
Unknown foreigner. Princess Diana still dead.
About a professor named Eric Kaufman who left his position at the University of London basically due to disagreements over the atmosphere of the university he was at in regards to how certain things he felt were not allowed to be challenged, and those things aligned with left-wing understandings of the world. I'm not saying he's right or wrong to believe that, I'm just sort of stating what the article claimed. The other article was similarly syndicated from a website called The Dispatch, and is what I will be commentating on today because it has a lot of issues. While the Supreme Court has developed various analytical tests to answer those questions, this is said in reference to what exactly does and does not count as First Amendment protected expression for those curious. In different contexts, it is fair to say that it has erred on the side of expression. That is most clearly seen in its general doctrine of applying strict scrutiny to the restrictions on expression based on their content. Any government effort to enforce content-based limitations will fail unless it can show that it is advancing a compelling interest in a way that is narrowly tailored to achieve that interest and in a way that could not be accomplished with a less restrictive policy. Some of our most controversial and celebrated Supreme Court decisions, think neo-Nazis marching in Skokie,
Illinois Nazis. I hate Illinois Nazis.
And Westboro Baptist Church members demonstrating outside military funerals have followed. And by outside the funeral, you mean 1,000 feet away, to the point where, quote, Snyder even admitted that he could not see or hear them during the ceremony or on the way. He had to encounter these signs on TV after the burial was over, and then found what they were writing on their website. I find the framing here rather notable, if only because it's based around this idea that this was not the plain reading of the First Amendment, but was instead something essentially created by the courts. And in case any of you think I'm exaggerating, the next paragraph begins with, "The court thus helped set the tone for free speech maximalism, or the idea that, quote, the transcendent value of expression guarantees that it trumps the cost of regulating it, in the phrase of political philosopher Joshua Cohen." I mention this because when one looks at the context the First Amendment was written in, the idea that it did not include ideologies like fascism or even just bigotries like homophobia is downright laughable. Remember, of the 55 delegates to the Constitutional Convention, around 25 of them owned slaves. As in, they literally owned other human beings as if they were property. Now, slavery was a controversial issue, even at the time, make no mistake. However, we were allowed to have completely free and uncensored debates on the topic, despite the fact that owning a slave is morally repugnant. As such, the notion that other repugnant ideologies would not similarly follow under free speech protections is downright bizarre. Again, say what you will about the ideologies expressed by those mentioned in the court cases. However, we have people who wrote the Constitution who similarly had giant moral failings. Ones they were freely allowed to express under the document they wrote. We are now in an era of free speech supramaximalism. Not only must speech prevail over regulation, but nearly everything is sooner or later described and defended as speech. It appears that many Americans subscribe to the belief that certain actions are unimpeachable as long as they have an expressive element to them. Or at least they lack the vocabulary to defend those behaviors as worthwhile on other grounds. 2 centuries ago, Alexis de Tocqueville remarked that, quote, scarcely any political question arises in the United States that is not resolved sooner or later into a judicial question. Perhaps his observation may be updated, that is, into a free speech question. Which, given the only examples so far have been related to the judiciary, specifically court cases, is for all intents and purposes the same thing. Yeah, that's one of those statements that sounds insightful until you think about it for a couple of seconds. Obviously, if you're trying to restrict somebody's expression, it's eventually going to become an issue of if they have the right to engage in it, at which point freedom of speech will be brought up, because that is the main concept which determines if you are allowed to limit such things. You might as well say any gun regulation eventually becomes a Second Amendment issue. Or any conversation about what powers the federal government has versus what powers the state governments have eventually becomes a 10th Amendment issue. You aren't wrong by saying that per se, but what are you expecting it to become exactly? Examples of this phenomenon are everywhere. On the right, for example, January 6th rioters recast themselves as mere protesters, and sympathetic media followed suit. The Republican National Committee censured Republican representatives for, quote, participating in a Democrat-led persecution of ordinary citizens engaged in legitimate political discourse. That is, for supporting investigations into the riot at the Capitol. The RNC did not distinguish between those who trespassed at the Capitol and even destroyed or stole property, and those who remained outside the building and within their legal right to protest. In the same vein, Donald Trump's lawyers argued that he had a right to use his words to try to stop the 2020 election from being certified. Quote, there's nothing that's more protected under the First Amendment than political speech, said one of the president's attorneys just after that indictment, which was dropped after Trump won re-election in 2024, was unsealed. I'm downright confused by your mention of the January 6th rioters, if only because obviously they're going to call themselves protesters, not because of freedom of speech supramaximalism, but simply because that is better PR than openly calling yourself a rioting seditionist. I have a similar issue with your mention of Donald Trump's lawyers. Obviously they're going to defend what he says as constitutionally protected speech, because they're his lawyers. Are you expecting them to say that their client engaged in lawless action? Because if so, they sound like really bad lawyers, I'm going to be honest with you. I mean, unless you're getting your understanding of lawyers from Wizards of Waverly Place.
You're good. You even got me convinced I'm innocent. My client has admitted guilt!
I mean, obviously not, given slightly later in the article you write, these characterizations are fair game for lawyers who are expected to put forward every non-frivolous argument they can think of in zealous defense of their clients, but it should be striking that leading media and elected officials across the political spectrum have latched onto them. But if that's the case, what exactly was the point of quoting a lawyer in the first place? Especially given a couple of paragraphs later, you essentially say it's completely understandable why a lawyer would say that. I also want to point out the article cited regarding those involved with January 6th attempting to make themselves sound like protesters specifically mentions how courts were not accepting that excuse, which is really weird because I thought courts were behind all of this in the first place. On December 28th, 2021, Judge Timothy J. Kelly of the U.S. District Court of the District of Columbia rejected these and other claims, citing cases including those in which the Supreme Court has upheld the right to burn U.S. flags in protest. He distinguished such legal expressive conduct from the defendant's actions in attempting corruptly to obstruct, influence, and impede an official proceeding, in trespassing, and in violently and illegally entering the Capitol building. Noting that the Proud Boys were not being prosecuted for what they thought or said, but for what they were reputed to have done, Judge Kelly cited the court's decision upholding the law forbidding the burning of draft cards in the United States v. O'Brien, to indicate that in cases where speech and non-speech elements are combined, quote, a sufficiently important government interest in regulating the non-speech element can justify incidental limitations on First Amendment freedoms. Kelly further rejected the argument that the laws at issue were overly vague or overbroad as applied to violent protesters in this case. Prosecution against Capitol protesters continue. Judges have already convicted and sentenced many trespassers and violent protesters. As a U.S. House Select Committee investigates the incident, it has subpoenaed former President Trump, his top aides, and even some members of Congress for phone records and other documents to understand their role in the event of January 6th and ascertain what actions might be taken to forestall such violence in the future. Trump has asserted executive privilege over such documents, but President Biden has, for the most part, failed to agree to this claim. In a decision that will likely make it to the U.S. Supreme Court, a 3-judge federal appeals panel affirmed an earlier decision rejecting Trump's claim. The same point is made in the article regarding Trump's claim of simply engaging in constitutionally protected speech, this time from Axios, where various legal experts point out that his words had absolutely nothing to do with the crimes he was alleged to have committed. Between the lines, the First Amendment would have played a bigger role here if the special counsel had charged Trump with directly inciting the January 6th riot. Political speech is heavily protected by the First Amendment, and it is extremely difficult to convict someone of inciting violence based on their protected speech. But that isn't a charge in this indictment, which may well have been a strategic choice by the special counsel's office. I don't expect there to be any serious First Amendment issues here, Rosenstein said. The left did much the same during the summer of 2020, defending mass rioting and violence by laundering it through the language and logic of expression. Many public figures and elected officials described unrest as the language of the unheard, echoing Martin Luther King Jr.'s famous quote. Then CNN anchor Don Lemon described cities in flames as torched by people who couldn't find another way to express themselves. A glowing New York Times profile of the demonstrators used one protester's description of a burning police station as its headline, a glorious poetic rage. Even if all that expression and poetry made Americans uneasy, they were meant to focus on its expressive content, its underlying message. The whole point of protesting is to make people uncomfortable, explained Representative Alexandria Ocasio-Cortez. Lots of actions make people uncomfortable, though, and some are illegal and immoral. AOC's statement only makes sense because if you interpret rioting as protesting, as mere expression. Okay, the quotes from Don Lemon and Alexandria Ocasio-Cortez were not defending these people involved, they were simply explaining why those who did these actions felt they were justified. Now, the quote from the New York Times, that one was absolutely celebratory, albeit I do think it's a bit of a leap to include it in the narrative you're trying to create here, but that's just a me thing. Reasonable people can disagree. But obviously you're going to find somebody supportive of these actions at the protest where it happened. Supramaximalism reached its apex late this winter, though. Former Columbia graduate student Mohammed Khalil has been detained and faces deportation for his role as a leader of Columbia University Apartheid Divest, an umbrella organization of campus anti-Israel outfits. Conventional wisdom quickly crystallized. Khalil was a protest leader who was being targeted for his anti-Israel speech, and possibly his organization's anti-American stances. Commentators across the political spectrum quickly slotted the Khalil case into that analytical framework. To put it mildly, I have little sympathy for recent anti-Israel campus protests, wrote Aliyah Soman, a leading classical liberal legal scholar. Nonetheless, deporting people for engaging in anti-Israel, pro-terrorist, or pro-Hamas speech is both unconstitutional and unjust. I just want to point out this article omits how that conventional wisdom was actually started by the Trump administration. Nathan Robinson of Current Affairs noted when he covered this story that the people who were making it an issue of Khalil's sympathies were Donald Trump and Marco Rubio, as they were specifically mentioning those as justification as opposed to these alleged other actions the article's about to say he did. Speaking of which, it is not obvious that Khalil would avoid deportation even if courts determined he were indeed being targeted for the contents of his speech. But it's also not obvious that speech is the best framework for addressing his behavior and his right to stay in this country. Khalil has a documented past of expressing his anti-Israel views through action, including unlawful action. He is on camera trespassing in a Columbia building as part of a demonstration. The group he was associated with has claimed credit for vandalism, including painting Hamas triangles on Columbia buildings and pouring a cement-like substance down university toilets. Two things. One, do you have any evidence of him committing this crime? If so, why didn't you cite a source for it? Second thing, what exactly do his associations have to do with anything? Also, this article got the story wrong, just so you all know. The article cited, which just talks about the cement-like substance situation, it has no mention of painting Hamas triangles. And it also says this was something the organization posted to their Instagram page and not an action they took credit for. At worst, the organization showed some support for doing this, but that is a far cry from being the ones who were actually behind it. Yet that is precisely the kind of argument that proliferated in the media frenzy following Khalil's detention, aside from the argument that he was being denied due process of law, which was proved wrong by Khalil's late May hearing before an immigration judge. The only mention of due process in the article cited was him saying he didn't expect it. That is a completely different statement. Our national self-conception encourages free speech supramaximalism in another way. Perhaps the most popular story we tell ourselves about why we ought to be proud Americans is that we have protested for and increasingly realized our founding ideal of equality of all people. Protest itself has thus taken a venerated place in our national imagination. Civil disobedience has become an amulet. College students and professional activists who can claim to be engaging in it think they have proved the righteousness of their actions regardless of the worthiness of their cause. But even assuming all else is equal, there is still a moral difference between trespassing to advance civil rights and trespassing to advance the total eradication of Western civilization. And those moral differences are obscured, often intentionally, by a hyper-focus on means and methods. There is a reason January 6th rioters and Columbia building occupiers alike fashioned themselves as protesters in a culture that makes freedom, self-expression, authenticity, and protest the highest good. Alignment with an abhorrent cause can be laundered into something not just legally protected, but even noble. Again, I think a more likely explanation is simply that calling yourself a protester is better PR as opposed to any alternative phrase that could be used, and that would be the case regardless of what our culture thought of protesters. That is, assuming it's preferable to being labeled the alternative. Also, even if there is a moral difference in the causes being protested, and I do grant you that for the record, that doesn't have any impact on how they should be viewed legally. If only because the entire idea of our system is that it is designed by fallible people who sometimes make morally incorrect decisions ourselves. As such, we should not be trusted with the responsibility of determining what causes are morally justified to protest against. This only highlights that the line between maximalism and supramaximalism depends on your conception of legitimate state interests, seeing that haziness clearly alongside the observation that supramaximalism subordinates all other considerations to free expression might counsel rethinking free speech maximalism as a cultural impulse. If maximalism has no limit beyond the consensus view of legitimate state interests, and that consensus is unstable, that could be a good reason to reconsider venerating speech as we historically have. Judges who understand the Constitution cannot be interpreted to create provisions destined to invalidate an ever-increasing list of state actions may even reconsider their jurisprudence. The Constitution doesn't establish a First Amendment construction of maximalism as embodied in strict scrutiny for content-based restrictions on speech. The Supreme Court did that. The court would have to reverse decades of precedent to undo its own work, but it has in recent years shown a willingness to overhaul legal doctrine that rely on abstract tests about means and ends. Reviving less abstract tests that privilege specific traditional limitations on speech would be hugely controversial, but might be necessary to put the freedom of speech in balance with other state interests in a way that will not invariably lead to speech's eventual domination. Okay, there's quite a bit wrong with this paragraph, so let's just go one by one. To start out with, although the Constitution cannot be interpreted to create provisions destined to invalidate an ever-increasing list of state actions, the Bill of Rights absolutely can be. For those unaware, the entire reason as to why the Bill of Rights even exists is due to a compromise with anti-federalists, who feared the Constitution gave the central government too much power. The entire point was to limit what the federal government could restrict, in order to make sure people's liberties were secure. This is also why the statement that the Constitution doesn't establish a First Amendment construction of maximalism is obviously nonsensical, if only because if it had failed to do such, anti-federalists would not have gone along with it, because that would have been giving the federal government too much power. Also, for those curious, that hyperlink on the word willingness is for a page on the case New York State Rifle and Pistol Association Incorporated v. Bruin, which is, and I mean this with no hyperbole whatsoever, one of the worst cases that could have been cited. First off, the case didn't actually see anything getting overturned on the court's end. Justice Clarence Thomas, who wrote the majority opinion, spent the first paragraph summarizing two Supreme Court cases on the topic of the Second Amendment, and then spent the second paragraph saying that, due to this precedent, the law they are discussing is unconstitutional. I'll even read that for you. In District of Columbia v. Heller and McDonald v. Chicago, recognized that the Second and 14th Amendments protect the right of an ordinary, law-abiding citizens to possess a handgun in the home for self-defense. In this case, petitioners and respondents agree that ordinary, law-abiding citizens have a similar right to carry handguns publicly for their self-defense. We too agree, and now hold, consistent with Heller and McDonald, that the Second and 14th Amendments protect an individual's right to carry a handgun for self-defense outside the home. The parties nevertheless dispute whether New York's licensing regime respects the constitutional right to carry handguns publicly for self-defense. In 43 states, the government issues licenses to carry based on objective criteria, but in 6 states, including New York, the government further conditions issuance of a license to carry on a citizen's showing of some additional special need. Because the state of New York issues public carry licenses only when an applicant demonstrates a special need for self-defense, we conclude that the state's licensing regime violates the Constitution. However, I also want to note that citing a Second Amendment case is just bizarre because we've been engaging in the same sort of maximalism with the Second Amendment that you're saying we shouldn't be doing with the First Amendment. D.C. v. Heller was the first time the Second Amendment was viewed as an individual right, as in individuals had the right to keep and bear arms. Anyway, my final thoughts are this article showed no understanding of the topics it was discussing. Good night, and good luck.